Welcome to another episode of Where the Stones Have a Story to Tell. This episode follows a prior one where we were out in the woods at Gilbert Hills State Forest, Foxborough, Massachusetts, came across an old building that had burned down, and it had two large safes in it. So I went looking for an answer of why those safes might have been there, and we found it. We found it in a book recently written about Abraham Lincoln. Strange set of circumstances. However, it turns out the owner of that burned down building was William E. Barton, a reverend and a prolific biographer and researcher and collector of information regarding Abraham Lincoln. A recent researcher and author by the name of Kevin Orlin Johnson believed that, among other things, that reverend had taken a bunch of documents out of government storage, if you will, courthouses, county records, and either used them for writing those biographies, or when they weren't very complimentary of the former President Lincoln, hid them. It's an interesting theory. After that reverend died in 1930, his memorabilia, his research, his documents went to 4 different locations by order of his will, one of which was the University of Chicago. Now, Kevin Orlin Johnson found a document in 29 feet of boxes that he says proves Abraham Lincoln was a slave owner and a slave seller. Thanks to Bill from Foxborough, we have that, or a copy of that document, and Bill helped me decipher a bit of it as well, because it's in 1850s legal handwriting. So we're going to go through that line by line and pick that apart. Does it really show that Abraham Lincoln was an owner and a seller of slaves, as Kevin Orlin Johnson writes in his book? Well, let's get to it. By way of backdrop, it's important to understand that this document was related to the distribution of the estate of Robert Todd, Abraham Lincoln's father-in-law. Robert Todd died in 1949 intestate without a valid will. He was married twice, had 7 children by his first marriage and 8 by his second marriage. Mary Todd Lincoln, Lincoln's wife, was one of 4 daughters by the first marriage. Now, that's going to be important as we go through the document, because men and women, heirs, male and female heirs, were not similarly situated always in the eyes of the law. Not having a will, the courts were going to have to go through all of the rights of the parties and order the distribution of the estate. This document that you see here reflects the distribution of some of those assets in Fayette County, Kentucky. Presumably, they would have to go county by county and petition the courts where property existed. All right, with that as backdrop, we're going to go through this line by line. Once upon a time, I was an attorney, member of 3 state bars. It's been a while. Didn't do any trust in the state's wills, and I certainly didn't practice in the 1850s, but I think I can deduce what happened in this document, both on its face and some of which is implied by what this document reflects. So let's get to it. It starts by stating the said, that refers to the parties that we'll mention in a minute, jointly and severally. That's a phrase, legal term of art, and it means the parties, in this case, come with equal set of rights, or that they're similarly situated in the eyes of the law. And in fact, we're going to see why that is as we go through this sentence. The said jointly and severally of N.E. Edwards and Elizabeth, his wife. I'm adding a little words and punctuation to make this make a little bit more sense. Now we are getting into the female heirs of Robert Todd by his first marriage. All 4 of them, 3 boys, 4 girls, all 4 of them are party to this document and this case, if you will, listed with their husbands. Why? Because in the mid-1800s, married women couldn't own property outright themselves, usually. Anything that they got went to their husbands. All right. N.E. Edwards and Elizabeth, his wife. Abraham Lincoln, Mary, his wife. Clark M. Smith and Anne, his wife. And William Wallace and Frances, his wife. All right. Now we have the parties. 4 heirs, all female, similarly situated because they presumably had the same exact type of rights to the property, different than maybe the boys, unfortunately, back in the day. And the husbands, for which are going to be the actual recipients of the assets of the estate that they may or may not get. All right, these individuals to a bill in chancery. A bill in chancery means that it is an equitable request of the court. In this case, and there can be a number of equitable situations one might want from a court, decisions from a court. However, in this case, this is specifically asking for distribution of assets of the estate. Bill in chancery filed in Fayette Circuit Court by, that name is scratched out. We'll come back to that in a second. Not completely germane, but interesting to speculate. LC. LC, as close as I could tell in this time, would have been abbreviation for law clerk. So the person scratched out may have been a law clerk who filed it. Not quite sure. Then it ends with them, referring to those 8 individuals who are parties to this, and a little symbol. That symbol could be several different things, but it appears twice in this document. So whatever it is, whether it represents plaintiffs or complainants, it represents the group of these 8 people individually. Legal shorthand is not uncommon, so very often when you are using the same word over and over again and it has the same meaning, you might just use an abbreviation, and that's what happens here. So in this first sentence, you have 8 individuals, 4 female heirs and their husbands, having either submitted a bill in chancery, which would be a complaint or a request for relief to the court, or have been party to somebody else's bill in chancery. Not clear, but also not completely germane to the analysis. Now, this next sentence is where the grist hits the mill, if you will, with regard to claims of slavery and Abraham Lincoln. Respectfully saving and reserving the benefit of exception. That's an old-fashioned way of saying the parties reserve the rights to object. However, they are willing that the slaves mentioned in the bill in chancery, shall be sold on such terms as the court may think advisable. Okay. We're going to come back to the interpretation of all of this in a second, but that is the hook that Kevin Orlin Johnson hangs his hat on in his book, demonstrating that Abraham Lincoln, and he really states that Abraham Lincoln alone is the owner of these slaves, and then the sale of these slaves. The next paragraph, they also consent that the real estate mentioned in the bill may be divided among the heirs. That's an interesting statement, and also we will pick that apart and juxtapose it against the selling of the slaves as to what was going on here behind the scenes. Finally, having said answered, they pray to be hence dismissed. So they basically are saying, with this, we got what we want, and we can be released from the matter. Kincaid and Breckenridge. Kincaid and Breckenridge, I believe, well, they were a law firm at the time, and I believe they were representing the estate of Robert Todd, not the parties in this case. So when you have an intestate estate, you've got all this property, money, personal items, whatever it is, and there's no will, the court will appoint typically an executor to oversee the distribution of the estate, and that executor may be managing the property for a period of time while things get settled, and also going to the court with the interest of the heirs, making recommendations as to what should or shouldn't happen, and generally overseeing the distribution of the assets out of the estate. All right, and that essentially is the goal of the executor in a case like this, finding all the right places for the goods and the property sitting in the estate. Okay, that part's kind of important. Let's get back to it. We've picked apart the first paragraph pretty well, respectfully, in reserving the benefit of exception. They, the parties, you have now that symbol again, the parties are willing that the slaves mentioned be sold on such terms that the court may think advisable. All right, I think on its face this shows that Abraham Lincoln did not technically own the slaves at any point, nor did he sell the slaves at any point. If we are going to cast aspersions on an individual that's arguably in the eyes of many historians, the greatest president in the United States history, we want to get the facts straight. Now, it may be that you conclude at the end of this video what I'm about to say is a distinction without a difference, and I accept that. I think it'll be interesting to see the debate amongst the viewers as to whether or not they believe this really reflects negatively or how negatively it reflects on Abraham Lincoln's legacy. But what this specifically says is that the slaves mentioned in the bill, and that is the bill mentioning property in the estate. Okay? Technically, Abraham Lincoln didn't own anything in that estate. He would only get title to anything that moved out of the estate. And in this case, the four daughter heirs and their husbands have come in and essentially requested that the slaves be sold, or at least agreed to the slaves being sold, and presumably they're going to get the proceeds of the sale. So, is there much of a difference between owning and selling slaves and coming into an estate as a party of interest and agreeing that they be sold and getting the money? Technically and legally, yes, but morally, I'll leave that for you to decide. There is no doubt on the face, if this document is authentic, that Abraham Lincoln did in fact knowingly, willingly agree to the sale of slaves so he would be getting a portion of the proceeds. That is without doubt in this document. There are some other aspects to this document that we can start to infer behind the scenes as to what was going on with the parties. So we mentioned the husbands and the wives. N.E. or Ninian Edwards Jr. in this case, it's left out of this, but his father was the Illinois governor at the time. He was a lawyer. The other two parties, William Wallace, a doctor, owned a drugstore, and Clark M. Smith was a carpenter, and he owned a general store, and then obviously Abraham Lincoln was a lawyer. I'm guessing that in the 1850s, it's a lot like today. If you're one or two of the lawyers in the family and the family has a legal issue, they're going to look to you and say, hey, what do we do? What are our options? What can we get out of this? So Ninian Edwards goes on to serve in Abraham Lincoln's administration once he becomes president. So one can guess that Abraham may have been in the driver's seat in the decisions here, or that he and Ninian were working it out together. But either way, that next paragraph after the one that mentions the slaves is interesting. They also consent that the real estate mentioned in the bill be divided among the heirs. There's no actual need for that line in this agreement. What they're saying is, yeah, as the law allows, we agree that it can be distributed amongst the heirs. The only reason it is in this document is because although we don't have the bill in Chancery, and we can start to conclude that the bill in Chancery was drafted by the parties, and quite possibly Abraham Lincoln himself, that there was a negotiation strategy undertaken by the parties, presumably at least 50% of which Abraham Lincoln came up with himself, with Ninian Edwards, or he came up with it all himself, that they were going to request a greater than equal share of the real estate that was sitting in the estate of Robert Todd. And this is not uncommon today. Certainly if you wanted to assert your rights and there was something you thought you wanted, but you might ask for something more so you have something to negotiate away. And I think this line, this paragraph here, they also consent that the real estate mentioned in the bill may be divided amongst the heirs. There's no way they need to actually consent to that unless they claim that wasn't the case earlier in the matter. So, we can infer from this document that Abraham Lincoln was involved in the legal negotiating strategy for the heirs, that they asked for something greater than they probably were entitled to with regard to the real estate and traded that away for allowing the slaves in that estate to be sold and those heirs to get the money. All right. Distinction without a difference, owning and selling or negotiating for the proceeds of the sale of slaves. You can be the judge. I think it's an interesting debate, and it certainly has been a fascinating project to dig into this. Again, thanks to Bill for digging this document out of the repository website of Kevin Orlin Johnson. It was sort of buried in there. All the links to the documents, the information shown here that exist on the internet are in the description. If you want to start doing your own sleuthing, have at it. But it would seem simply on the face, if you don't accept my analysis of the inference behind the text, on its face, Abraham Lincoln, the 16th president, did in fact agree to a distribution out of his father-in-law's estate that involved the selling of slaves and receiving the proceeds, or 1/4 in this case. All right, as always, thanks for watching. We'll see you next time.